and welcome to Know Your Rights. I am Janelle Mencias, your host for tonight's show. On our show, you hear directly from attorneys who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. Tonight, we will be discussing the issues surrounding foreclosures and bank sale of property. You can watch us live on Channel 7 or on Facebook at Colorblind Multimedia Productions. You can also participate in the conversation by posting your comments or questions on our Facebook page. Tonight, joining us to shed some light on this topic is attorney Aldo Salazar. Good evening and welcome, Aldo.
Good evening, Janelle. Thanks for having me.
So, we've seen the word foreclosure a lot in the US media. I don't necessarily hear it a lot in Belize, but tell us, is foreclosure something that we do see in Belize, and what exactly is it?
Right. Well, this is kind of a little pet peeve for me because I'm involved in the banking field quite a bit, and bankers, many bankers and lawyers and people involved in the field do refer to it as the process as foreclosure, but we don't really do foreclosures in Belize. Although you would see in the newspaper that foreclosure are being advertised. Foreclosure is one of the remedies that you get when you have a mortgage. The others are the sale of power of sale and the right of possession. Without getting too technical, in the mortgage process, really, in the sense of foreclosure, the mortgage process transfers the right to the land to the person lending the money. And what foreclosure means is that the right is then vested in the individual who loaned the money, so that he then becomes entitled to the interest in the property. That is really what the foreclosure process means, that the person is no longer entitled to recover that property from the lender. In Belize, however, what we have is created over land is a charge, and that charge, it's a legal mortgage. It's a charge, but that charge basically charges the land with the repayment of a certain sum. And if you don't repay that sum, then the bank has a power of sale. So that is the remedy which banks utilize in Belize, the power of sale as opposed to a foreclosure. But we call the sale foreclosure still.
Now, you spoke about the default on payments. What is the process that comes after, since you said we don't have foreclosures in Belize?
The process depends on the nature of the land, because in Belize we have different pieces of legislation which govern mortgages or charges. One is the Law of Property Act, the other one is the Registered Land Act. And there are subtle differences with how those acts regulate the power of sale by, in most cases, banks or whoever the lender is. What is similar across both of them is that there's usually a default in the mortgage money. So it is usually a default in principal and interest. If, for example, in the Law of Property Act, if there's a default of principal and interest, as well as the Registered Land Act, then that triggers the process. As well, if there's a breach of one of the conditions in the mortgage, say there's a condition that you must keep the property insured, and that insurance must be assigned to the bank or to the lender. That is not necessarily a breach of the covenant to pay the mortgage money when it's due, but that's a breach of one of the covenants in the law. So where there's a failure to pay the money or there's a breach of another covenant, the bank's power of sale can be triggered, and the bank can demand the money, or it can demand performance with that particular covenant, that particular requirement. Once that is done, if that money remains outstanding or if the covenant is not remedied, you don't act in accordance with what your agreement is done, then after a period of 3 months from the date of the demand, then the bank has a right to exercise its power of sale. In the case of the Law of Property Act, which has to do with unregistered land in Belize, as I said, you have two types of land systems. So in case of unregistered land, the Law of Property Act prevails, and in that case, you must also publish an intention to sell that property for at least 2 months prior to the date on which you would sell. So the bank does have to meet those requirements. There should be a demand and there's a waiting period. For a particular type of land, then you need to publish the intention to sell. Most banks still publish the intention to sell generally for all parcels of all types of land holding in Belize, although there's no requirement to do so in respect of registered land.
Okay. Now, at what point does the bank decide that it'll post the notice?
Okay.
Is that after you've been warned, and how quickly are you warned about that?
Well, although under the law, the banks have the power, in the case, the banks have the power to say demand after 14 days in one case.
Okay.
They have the power on any default of principal or interest. Banks primarily, as I understand it, in practice, they have a period by which they will demand, say, 30 days arrears, 60 days, 90 days. I believe that, but this is practice for the banks, primarily to coincide with some rules that they have with central bank. After that, then the bank will issue that final letter by which it is saying, you either comply or will be forced to exercise a power of sale.
Now, what are the bank's rights and obligations once that warning has been given?
Once the warning has been given, ordinarily what will happen is that you will have to have an auction. Banks will usually sell by public auction. Although in some circumstances for unregistered land, the bank can go by private sale without having to go to court. For registered land to exercise a private sale, the bank must get permission from the court. So generally it will go by public auction, and that the bank is obligated by law to ensure that it fetches the best price available. So there is that obligation on the bank. So when it goes to the market, it has to try to get the price that's the best available for that.
As possible.
Yeah.
Now, in terms of the advertisement of the property, how long does that take before you actually go to the auction?
Well, there's no set rule mandating that a bank has to publish it a certain amount of times or at certain time before the auction, but banks are governed by the best practice. So because it's all, remember, we need to ensure that you fetch the best price available. So you need to ensure that if you're going to publish an auction, it has to be in a newspaper that has general circulation. You don't want to publish it somewhere where it won't be seen. Otherwise, the complaint can be made that you didn't put it out there on the market. So banks, traditionally, they have a practice which they do. They would publish several times in prominent newspapers in order to ensure that the most attention is gathered to the auction sale. So you would see from our reading the newspaper, you will see that there are quite a number of auctions happening, and these are usually repeated.
Okay, so they just go on until
it really depends on the particular practice of the bank, but most banks will try to have it repeated so that the auction is very well published, because that is going to discharge them of that, well, I wouldn't call it burden, but that obligation to ensure that the best price is gotten for the property. That doesn't mean that you have to sell for what the property is valued, market value. But you need to be able to sell for a reasonable value. But we can discuss that a little bit.
Now we'll take a short break, and when we return, we'll talk a little bit more about what borrowers can do when they default on payments. And welcome back to Know Your Rights. Tonight we're discussing foreclosures with attorney Aldo Salazar. Earlier we spoke about auctions. One of the things I'd like to know is how does the bank determine what value the property will be sold for?
Yes, like I said before we went to break, the bank has an obligation to get the best price available on the market. But that doesn't mean that because you feel that, say, your property is valued X amount, that is the price that the bank is obligated to get. Because the bank sets its reserve price for auctions based on what is called a forced sale value, not the market value. Usually when you have a bank sale, the property is already distressed, so people in the market are know that that property has to be sold, and therefore you will never be able to get the actual market value of that property if you were doing an arm's length sale from one party to another. So valuers, people who value land, also provide a market value and a forced sale value, and that is what the bank uses to fetch to go to the market. However, that does not mean that the bank is obligated even to sell for the forced sale value, because at the end of the day, what the bank has to do is to ensure that it gets the best price available for that property. If it goes to the market at auction and even the for sale value is not available, the bank will go back, and if it still doesn't get the value that it has adjusted, it will keep going back to auction, and that can drive the price down. And once the bank can prove that it did its best to get the best price available, then the bank has satisfied the obligation that it owes to the landowner.
Now, I know we jumped straight into auctions, but does the borrower have other courses of action that they can take other than just, putting up their property for sale?
Yes, there are. It depends on the position of the borrower. It is always in the best interest of a borrower if he cannot pay the bank, or if he finds himself running into trouble or foresees that it's going to be trouble, that he should, and I know I can say this because I've worked in a bank before, that he should really approach the bank from very early and let the bank know he's having difficulty. I think most banks, people feel, or the banks have the reputation that they want to sell, but the bank's intention is never to sell, and it's not in the business of real estate. The bank's intention is to collect the money that is owed. So it's never the intention to sell somebody's home. But I think the earlier you notify the bank, you try to work with the bank, the better. If you are able to negotiate a sale even before the public is aware that your property is distressed or is going to be sold, that is one way that you can assist in fetching the best price available. So there are things that the borrower can do if he's really not in a position to pay the money. If you can approach the bank with a comprehensive plan, but the borrower should really be proactive,
right,
to try to assist in his situation.
And the bank would determine the amount of time they have to pay it based on the amount, or are there special conditions?
Well, there are certain rules which the central bank, as the regulator, has imposed, but if there's a change in circumstances, the bank can have a restructuring of the loan facility. The bank can give you a grace period, interest only. So there are things that the bank can do to assist. But it's really incumbent upon the landowner to approach the bank if trouble is foreseen. Yeah.
Now, you spoke about the fact that the property might be valued at a certain amount, but you won't necessarily get that amount once it goes up for auction. Once it's sold, what does the homeowner get? What does a borrower get?
Well, it depends on what the property is sold for. If the property is sold for an amount in excess of that which is owed to the bank, plus is not only principal and interest, at that point the bank is going to have auctioneer's fees, the bank is going to have late payment fees, is going to have attorney's fees if they've tried to collect otherwise. So once those fees are all cleared, the balance of that purchase price is for the account of the borrower.
And of course, if it's the opposite way, then the borrower still has the obligation to pay.
Right. In most agreements with banks, the borrower will still be obligated to pay that money because the land is security only. That obligation will still be there.
Now, when your house is up for auction, obviously it's because you've been unable to meet the financial obligation. But then on top of that, you have all these legal fees and these penalties. Is there like an acceptable rate that the bank can impose on the borrower?
Well, there's in terms of fees, I think that those need to be, I think, negotiated and very clear from inception of the facility, so that it is at the inception of the facility that you have your bargaining power, especially in a competitive environment. So you need to ensure that you have notice of all fees that are going to be charged, and that is when you can negotiate, because at the point of default, you really don't have that negotiating ability. Of course, if you feel that the fees are excessive, then you're always free to go take your business to another institution. So banks are competitive at that point. So I think that is really the point at which you want to be looking at fees. But everything is based on the contract that you negotiate with the bank.
Now, what advice would you give to someone, like I said, well, we already spoke about this, where you said, the earlier you take action, the better it is. But what about in the case where that hasn't been the action that the borrower has taken, and they decide to step in late? Mm-hmm. Can they still have an agreement?
Well, yes. My advice would be that it doesn't matter at what point, but my advice would be not to be adversarial with the bank, because it really does not benefit the borrower. The banks are generally, from my experience, willing to negotiate. The bank hardly ever wants to go to auction, because you hardly ever fetch the price, the market value, as I said. So for me, I think borrowers should have an open mind and should be open to negotiate with banks when this happens.
Now, we're at the point where the property is coming up to be sold. I now have the money to pay. Can the sale be stopped? Are there charges to me as a borrower? Because now, it's the same house that I'm basically defaulting on, and now I have the money. How does that work?
Right. Remember, we spoke about when you create a mortgage or when you create a charge. A charge by way of legal mortgage is what is called. When you create that, the person who borrows the money always retains what is called the equity of redemption, means the right to redeem your property from the mortgagee. And you maintain that right up to the point at which there's an auction, up to the point at which the bid is accepted. So you are able to redeem your land, meaning you're able to get it back up to that point. So even after you've been demanded the 30 days, 60 days, 90 days, even at 120 days when you get your what is called the demand letter, the charge letter, even after your property is being auctioned, right up to the auction date, if you have the money to pay or if you find the money to pay the mortgage money plus interest plus fees and expenses, you can stop the auction.
And just an additional question, are you able to also purchase back the property at the sale price at the auction?
Usually, if you are the borrower and you're not going to be allowed to purchase your property for a cheap and discharge your obligation, you can do it by paying the bank, but your obligation to the bank for the balance of the purchase price
is a priority.
Is not going to be given up. The bank will still have a right to demand the balance of the money from you.
Okay,
right?
That makes sense. We'll take a short break, and when we return, we'll answer your questions. Welcome back to Know Your Rights. I am Janelle Mencias, and our guest tonight is Aldo Salazar, and we are discussing foreclosures and bank sale of property. We thank you for your questions and comments. We have selected 3 of your questions to ask our guest attorney, Aldo Salazar. Andrew wants to know if he owes $50,000 on his property, which is worth $150,000, and the bank is selling it for just $60,000. Can he stop the bank from selling it so cheaply?
That really depends on, like I said, the bank is obligated to sell for what it can fetch on the market. Means that if your property is valued at 150,000, the bank can just decide I'm going to sell it for 60, and because I'm owed 60. The bank has an obligation to go to the market, to auction, to get the best price. But if after going to auction several times the market is only giving 40,000, the bank can sell. So it really depends on the circumstances. It means that the bank cannot just do it intentionally, but if the bank has demonstrated the best effort and that is all that it can get, the answer is yes, it can.
And so that's also in fairness to the borrower as well.
Right. It's in fairness to both the borrower and the bank, because the bank.
I mean, obviously,
right.
You've already made a huge amount of payments towards it. I'm hoping that the borrower would have made so many payments already. So.
Right. So there's a balance, because you can't sell for whatever you feel like, for peanuts.
Right.
And also you can't expect the bank to wait 5, 6, 7, 8, 9 years until it can get that price that you want for it.
Right.
So it has to strike a balance. You just have to demonstrate that you have done your best to get the best price available.
Now, Andre also asked if the bank should give him the profit they made off his property if the bank sold the property for more than he owed.
Yes, the answer is yes. If the bank sells for more than what is owed, then that is for the account of the borrower. The borrower is entitled to it. Those are very few and far between, but it does happen.
Now, Karina asks, if the bank has sold your property, but the bank didn't get the amount you owed them, how long after the sale can they try to collect for the balance?
Yes, like we discussed a little bit earlier, some people feel that once the bank has tried to realize its security, meaning it has gone after the security, then that you don't owe the bank anything else, even if they didn't sell for, even if they didn't recover, but that's not true. The bank is entitled to the sum which it loaned to you plus principal and interest, which is what your agreement was with the bank. So the bank is able to recover that amount. Sorry, you could put up back the question. Let me see. How long after the sale can? Sorry, the bank can go for 12 years. The mortgage money that is owed can be collected by a bank for up to 12 years.
Okay.
After the date on which that money became due. This is from the date when you miss your payment, or it can be from the date when the bank demanded. But there's a limitation act provision which says that it's 12 years.
Now, one of the questions someone also had was regarding within the institution itself, if there are people who might have ill intentions, how is that dealt with? It might be like a conflict of interest. Maybe they want the property for themselves.
You mean like persons within the bank?
Right, within the bank.
Well, that can be
tricky.
The case, but you would not be somebody within the bank with knowledge should not do that. But you can, they can have somebody get it independently of them. Really, once the market price is available, once somebody pays that market price, or once somebody pays the price, which is the reserve price, which you get at auction, and that fetches the highest bid, then it's very difficult to trace, whether there was.
Right.
But really, the bank should not share that reserve price. The bank should not disclose that amount that is going to accept, because it is going to be contradictory to the principle that it has to fetch the best price for the customer. And that is why reserve prices are really kept close to the bank, because if people know what the reserve price is, then they'll want to go and bid exactly above the reserve price. When in reality, it benefits everybody if you fetch a higher price. So.
And now that we're wrapping up, any final thoughts or words of advice that you'd like to share with our viewers?
Yes, my words of advice, I'd want to repeat what I've said. I think I mentioned it twice, but it's very important that if you foresee that there is trouble with the bank down the road, the banks really do not want to sell real estate. Banks really want to avoid having to go down that road. It's very expensive for the bank. When you see the bank selling real estate, the bank has already had to take money out of its pocket to put into reserves in the central bank. So that affects the bank's bottom line. So banks really want to avoid that. The key is to go to the bank early and try to negotiate. Do not be adversarial with the bank. People get upset, but the bank is simply trying to recover its money that is due to them under a lawful contract. So I think that the best advice is to see your banker. If you don't get a response from your banker, you see somebody who is in the system above him or her. I think that is very, very, very important. And also, when you're entering into an agreement with the bank, I think it's good that you ask a lot of questions, ask to see the fees. Don't be attracted just by a interest rate.
Right.
Ask what is the default interest rate. When will the bank change interest rates? Some interest rates are fixed, but only for a certain period of time. So ask a lot of questions at the inception and know what it is that you're getting into, so you're not taken by surprise at any point later on.
Right. Thank you very much for this really healthy discussion on foreclosures, I guess. But we learned a lot about auction and what recourse borrowers can take. So thank you very much, Aldo.
Sure. Thank you. Welcome.
We have come to the end of our show for tonight. Thank you, Aldo, for joining us and providing so much information on tonight's topic. Know Your Rights will be back next Monday with attorney Deshaun Arzu-Torres, who will explain how to get access to courts for justice. Tonight's episode will be repeated at 1 p.m. on Sunday on Channel 7, and it will also be available for viewing on Facebook and YouTube. Thank you for watching, and good night.